There you go.
Okay, we're going to go ahead and get started. Thank you. We've had some difficulties this morning, so we're going to go ahead and get started, and then the chair's going to join us in about 20 minutes. So we will go ahead and call the meeting to order and start with roll call.
Thank you, Vice Chair. Vice Chair Durrett.
Here.
Justice Douglas.
Here.
Member Merritt.
Present.
And Dr. Mazarana.
Here.
We have a quorum, Vice Chair, and please, Amber, mark the chair present when she gets here. Thank you.
Thank you. That will take us to our first public comment. Do we have public comment here in Southern Nevada? Please be sure to keep it to 2 minutes.
Vice Chair, before we begin, I'll have to read the telephone joining information.
Okay, thank you. Please go ahead.
To provide public comment via telephone, call 669-444-9171. Enter webinar ID 875-0305-8802, followed by passcode 370002.
Thank you. Okay, please state your name and go ahead.
Morning, board. I'm back again. Hello, everyone. So my name is Tara Baker. I'm with EOB Disposal Solutions. And again, we are an option for your waste management here in Southern Nevada.
Thank you.
Thank you.
Hi, everyone. I'm Shanna Perry for the record. Cannabis is my company. I plan on getting my lobby license next month. I just recently, the last couple of months, was running a federal super PAC for a presidential candidate. So I'm planning to do a federal. I'm working with some people out of New York, and we're drafting up some federal a federal bill to take in hopefully for next year. And some of this is going to translate on there. There's a lot of other stuff that's going to be on there, but I plan on getting my lobby license next month for Nevada specifically. And I feel as though these regulations need to change. I did find the packaging for that extra go bag that's very bad for the environment, which I'd like to amend. It's like a 6, I found it NRS 6 something. And as far as the micro businesses, so I didn't know if there's anything on this list that you guys are able to do, or if all of that has to go through legislation. And, you know, anybody that would like to support any of this, the lady with the waste management was just up here, and we were just having a discussion that the items that you guys are still throwing away creates revenue. Small businesses can make products, more additional taxation, things like that can occur. I'm very nervous too on there as well in regards to taxes. Federal's going to come in and they're going to have their own tax that they're going to add on, right? So if our taxes are already at 16 to 20%, and they're going to add on, if we're just going to keep adding and adding, there's going to be a huge black market, and Nevada's not going to be able to compete with places like Oklahoma. So until something like that is moved, reassessed, figured out, I don't see Nevada being very competitive on the national market going forward. Also, we're looking down 2 different areas. In my opinion, what I've witnessed in the political realm is that on one end.
You're at 2 minutes.
Oh, okay.
I just want to keep it consistent.
Yeah, no problem. So anyways, Cannabis, I'm going to lobby, and let me know if you guys want to do anything and get anything in this federal bill that I'm working on.
Thank you. There's also public comment at the end as well.
Oh, okay. Thanks.
My first time around, so I'm not sure how this works, but I think you invited me to say something.
Yeah, well, you would take a seat there, state your name, and you have 2 minutes to.
That's easy. My name is Don Nassif. I own a company called Crown Air Quality. We specialize in air purification systems, have since 1977. Been in the city for over 30 years. We do 95% of all the bars that have air cleaners for cigarette smoke removal. We do them. 30% of the casinos, we do them. But now we're moving into the marijuana smoke industry. So we're here to serve the industry. I just wanted to make myself known so that this industry can enjoy our services. Thank you.
Anybody else in Southern Nevada? Do we have anybody in Northern Nevada?
There's no comment in North.
Do we have anybody on the phone?
If you wish to provide public comment, dial *9 to raise your hand if joining by phone, or click the raise hand icon if joining by Zoom. There's no online comment.
Thank you. Okay, so then we'll move to the meeting minutes for the September 19 meeting. Everybody's been provided the materials and the opportunity to read over the minutes. Can I get a motion to approve the minutes? If anybody's so inclined.
Member Douglas, for the record, so moved to approve the minutes.
Member Mezrine, a second set.
Thank you very much. All in favor?
Aye.
All opposed? And accepted. We will move on to the consent agenda. These matters can be taken as a whole, and we could choose to vote on all of them at the same time. If anybody would like to pull any of them, please let me know. Okay, thank you. We might get through this before the chair gets here. Okay, so the consent agenda, would anybody like to put a motion forward on how to proceed on the consent agenda?
Move for approval of item A under the consent agenda, items 1 through 9 for approval.
Member Mezrine, a second set.
Thank you. All in favor?
Aye.
Aye.
Aye. Aye. All opposed? Okay, thank you. That also passes with 4 in favor. So next we have the consideration of the proposed settlement agreement, and do we have a briefing on that?
Yes, Vice Chair, Tony Garassi, Senior Deputy Attorney General. Good morning, board members. I will be presenting the settlement agreement on 4A. It is for CCB matter 2024-010, CCB v. Matrix NV LLC. Matrix operates in Clark County. They possess cultivation, production, and distribution licenses. The subject of this settlement agreement are licenses C150, P095, and T049. A complaint against Matrix was approved at the May 2024 CCB meeting. At the time of the complaint, Matrix held dual cultivation and production licenses in addition to its distribution license. Allegations against each of those licenses were included in the complaint and are resolved by the settlement agreement. Since that time, 678B.215 has been revised, and Matrix 2 sets of dual licenses have been combined into a single license. So now it holds a single cultivation, single production, and single distribution license. After the CCB approved the complaint, but prior to service, the CCB, through the Attorney General's office, contacted counsel for Matrix, and we engaged in settlement discussions. Service of the complaint and any subsequent answer deadline were held back as settlement discussions ensued. After discussions between myself and Matrix's counsel, the parties were able to reach a settlement in principle pending the approval of this settlement agreement. Thus, there has been no complaint served and no answer filed. As set forth in the settlement agreement, the allegations underlying this disciplinary action arise from a routine audit in May through June of 2023. There were allegations against each of Matrix's 3 license types. Those allegations are outlined in paragraphs 7 through 14 of the complaint and paragraphs 4 through 6 of the settlement agreement. As further set forth in the proposed settlement agreement, to resolve these matters, Matrix admitted to 2 separate violations: a Cat 3 violation as to C150 for failing to keep any required records, including seed to sale tracking requirements, and a Category 3 violation as to P095 for failing to meet requirements for the disposal of cannabis waste. Matrix also agreed to pay civil penalties in total of $10,000, allocated equally between C150 and P095. Matrix was given the option to make a one-time payment in full or to pay equal payments installed every 10 months, first payment being due 30 days from the date of the approval of the settlement agreement, meaning if it's approved today, the first payment would be due November 15th of 2024. CCB staff and council fully considered the mitigating factors in resolving this disciplinary action. Those are outlined in paragraph 14 of the settlement agreement, and the parties have agreed to equal weighing of the mitigating factors. CCB staff and council also fully considered the factors set forth in NCCR 4.030 subsection 2. This includes consideration of the size of Matrix business as well as its ability to pay. Those factors were also considered in determining an agreeable payment plan. Given the violations alleged, civil penalty amount is reasonable. Respondent also agreed to a plan of correction, which is detailed in paragraph 26, and the CCB staff has approved this plan of correction. The plan of correction was implemented immediately by the licensee upon notice of the violations, and the licensee has confirmed the facility is now in full compliance. This is one of the mitigating factors. Based on all of that, the Attorney General recommends and requests the board approve this settlement agreement. I'm free to answer any questions as well as counsel for Matrix. Thank you.
Thanks. Does the board have any questions before we ask Matrix to see if they have a presentation?
Member Douglas, for the record, how they complied with the requirements as to the outstanding renewal of necessary cards for the facility as well as business licensing in the areas.
Yep, they are fully renewed and fully up to date on all of those areas.
And the last question, is Matrix having that kind of financial difficulties that this should be spread out over 10 months?
I defer to Matrix counsel on that. I don't know the ins and outs of it, but it was a request from the licensee that CCB and council considered and were agreeable to. So I defer to Matrix on the ins and outs of that.
Mr. Graff, I know we're putting you on the spot since your client isn't here, but
Actually, Your Honor, my client is here. Mr. David Tettleman's in the audience. Also, Chad Westham is our point of contact, and he's available in the Carson City office, Your Honor. So again, Rusty Graff on behalf of Matrix. Your Honor, we did have a significant conversation about the monies and through the taxation and everything else, and we encouraged the CCB to look at that so that they could see that we're not a huge operator, that we're not one of the larger ones or the bigger ones. We're not pulling down the revenue that other companies are, and that type of payment would be financially burdensome on them. I will tell Member Douglas that in particular, the agreement says that the first installment is 30 days from execution of this agreement, but it also has in this agreement that it was to be paid on October 15th. And we made that first payment so that I anticipated that His Honor may raise this question because I've seen him do this in other instances. So to show our good faith, we made that payment on October 15th. So, there are a number of things that we went back and forth. This is an incident that occurred actually in 2020. There was it was an issue or an investigation or an audit that occurred that we went back and forth on in several different versions of amended plans of correction and that sort of thing. We really they did a lot of work. We ended up hiring Mr. Weston to come in and be the point of contact and to be our compliance person. We changed policies, we changed procedures, and they really did a lot of heavy lifting to address this issue.
thank you.
Member Durrett, for the record, I think Matrix has been through a few management changes, right, over the last few years, so that could probably contribute to.
At least two, yes, with their general manager, and Mr. Weston's been the compliance officer and the point of contact for at least a period of almost a year now.
So most of the conduct goes back to 2020?
It's all in regards to an audit or an investigation that occurred in, I think, September 2020, I believe.
Oh, wow, because it seems like that would be difficult to deal with, it was all different people back then. And
That you hit the nail on the head but to their credit, they've done significant issues as to policies and procedures to address some of the documentation issues that are raised in both of those complaints, but also in the training and the going forward is significantly different.
It's probably really good for you guys that this wasn't in 2020, that it was coming to the board now that there have been a lot of changes on discipline. And I'm happy to see that this was so collegial and ended up in, fines that sting, but probably won't put you out of business. And I also, I appreciate all the work that went into it on both sides. I still think the board, the board still needs to analyze the factors set forth in statute, including mitigating circumstances. But I do think this all, my opinion seems fair on both sides. Do any of the board members have anything to add or any questions before we go forward with the vote? Okay, so on this matter, we will go ahead and take a vote. Or I'm sorry, a motion.
Member Mazarana makes a motion to approve the settlement agreement to resolve the disciplinary action.
Member Merritt, I'll second.
All those in favor?
Aye.
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 Any opposed? This has been approved. Thank you so much.
Thank you.
Your call. Yeah, so if you wanted to move around to the license agreements.
We're going to move the agenda around a little bit. We're going to do agenda item number 6, relating to the approval for a conditional license for cultivation and production.
Vice Chair, would you like me to read it?
Yes, please.
Vice Chair Durrett, Justice Douglas, Member Merritt, and Dr. Mazarana. For the record, I am David Staley, Division Chief of Investigations for the CCB. I'm here to present agenda item number 6, which consists of one request for approval of conditional licenses. Item A are applications by True Harmony Company LLC for medical cultivation and production licenses in White Pine County. On July 23rd, 2024, True Harmony was the only applicant for a proposed White Pine licenses and was informed that it met minimum scoring requirements on August 7th of 2024. The White Pine County licenses are a new licensing round requested by White Pine County because no medical licenses had previously been approved in that county. True Harmony is an affiliate of Silver Lion Farms LLC. Silver Lion is an organic farm operated in White Pine County that grows alfalfa and hemp and plans to lease certain acreages to True Harmony for its proposed cannabis cultivation. John Anthony DeHoria is a part owner of Silver Lion and sole owner of True Harmony. If approved, True Harmony will need to perfect its conditional licenses and receive final approval before initiating operations. No areas of concern were developed during this investigation. I would like to point out that True Harmony has been extremely responsive to all information requests, which helped us complete its suitability investigation in time for this October agenda. The investigative agent indicated that all information requests were fulfilled either the day of the request or the next business day. As a result, the investigator experienced no interruption of their work and was able to complete the investigative report quickly and efficiently. I'm available for any questions, and my understanding is that Robert Karelko, Catherine Linneman, and John DeHoria are available to address any questions you may have as well. With that, Vice Chair Durrett, I'll turn this item back to you.
Thank you. Do we have any board member questions before we ask the potential licensee to they have a presentation? Okay. All right. Would the potential conditional licensee like to make an affirmative presentation?
Yeah, just good morning, CCB board members and Executive Director Hum. My name is Bob Kuroko. I'm the CEO of True Harmony Company. We're here today seeking approval of the conditional license for the cannabis cultivation and production establishment in White Pine County. Today, I've got Catherine Linneman. She is our Chief People Officer for True Harmony Company. I've also, with me, I have Bridger Morgan. Bridger is the head of greenhouse operations and production, and James Osh is our cultivation manager. John Anthony is our managing member, and actually he intended to be here today, and he had a little bit of an issue. He had a family concern. He went to Texas and had a flight out last night, and TSA actually blocked him from getting on his flight back. I understand in Texas, they are implementing a new system for identity verification, and his license had a physical damage to it, and the reader couldn't read it, and they blocked him from flying here today. I have never heard of this in my entire life. It's crazy. But John Anthony, we did scramble, and John Anthony is with us somewhere on a screen, or we got him plugged in. So he is here. We made it work. So we've gone through an extensive application process and finished everything and completed a thorough suitability examination with CCB staff. And I just figured the best way to go here is just open it up for questions for the board. We're excited that this day is finally here.
Member Douglas, for the record, congratulations for getting as far as you've got at this point. The question, what is your anticipated, nobody's holding you to it, operations to begin? What are you hoping for?
What are we hoping for? In terms of, could you give me a little more?
Begin production and.
We are ready to go. We've been chomping a bit for several years now. We've made some additional investments in the facility to make it really conducive to cannabis. We'd like to be operating next month if we can. Not a big surprise, right? Yes.
Member Durrett, for the record, so who all lives in Ely, where I was born, by the way?
We're just north of it.
I really want to come out and visit this facility.
We would love to have you out there.
Should field trip. What can we do with that?
You got it.
That'd be awesome.
So what's happening with the hemp operation right now?
The hemp operation is still there. So we have Silverline Farms that has a large alfalfa business. We're actually the premier supplier for the West Coast for alfalfa, and we do some hemp, but we're going to focus on the cannabis side inside that glass house.
I'll ask more about the cannabis, but the hemp, are you selling hemp? Are you, because the initial plan was to put it into products, but the FDA has kind of dragged its feet on being.
We actually sold the last bit of hemp that we had in stock last month. So we will continue to grow hemp, but the market is really not conducive to doing it at scale right now.
Why? Is that because of the lack of FDA action on?
I think it starts there.
Or
the Silverline Farms, talk about the other companies. Silverline Farms was built to be a large supplier for the consumer packaged goods industry. And the big players in the industry won't jump in until it's safe. And they need a safe legal framework to do that. And until that happens, starting with the federal government, it's a little bit here and a little bit there. We still get a lot of custom orders. We fulfill them, but we're not able to fulfill our mission on Silverline Farms right now until that is cleared up.
Correct me if I'm wrong. I'm just wildly guessing here, but I would also think that maybe it's because the proliferation of CBD products, they're poor quality, not tested, and so it's probably hard to compete with these cheaper, less tested products.
It's a deeper conversation on the CBD side. I think that's one of the reasons that the state and federal government needs to work together and figure this out, because we have very poor quality out there. Consumers are buying packages of CBD products that it's all over the place. It's not what's on the label. And until that, there's actually laws in the state of Nevada that were passed a couple of years ago, but they're not in action yet because the regulations haven't been written. So that's another thing that we can control in the state of Nevada, is get that fixed.
Okay, so with the cultivation and production, is there kind of like there's a lot of supply online. We just did a market study and we don't really have a lack of supply in Nevada. What's the plan? What's the angle to be kind of stand out from other?
Yeah, we've looked at the market and we see a great opportunity at their really high quality. There's a glut in the middle right now. There's not enough at the very lower end for extraction and the higher end. And I think we can fill that void.
How big is the facility?
We have 4 bays that we're allocating to this business for True Harmony. There are 20,000 square foot grow bays. That's under lights. So now, are we going to start with all of that? We are not. We're gonna stick our toe in there and start to build it up. But hopefully over time, we can use up to 4 bays.
And will it be greenhouses?
This is a high-tech Dutch glass house with individual sealed grow bays with individually operated by a computer. It's about as high-tech as you can get. And I think the highest tech facility in North America.
The last thing I'll say is we've seen issues when people, I don't want to increase your costs, but we've seen issues when people don't have local counsel extremely familiar with the rules, with compliance. So I would encourage you to really get to know our rules, Nevada's rules, and which I know you've been coming here for 4 years, but I would encourage you to get somebody.
We understand that is critical. We're not looking to jump in and be a problem for anybody in the state or county. We want to do it first class all the way. We've identified a very seasoned individual to lead our compliance effort. We know it's critical for us.
Those are all my questions. Does anybody else have any questions? Okay. I would like to take a motion on agenda item 6.
Member Mazarano makes a motion to approve the conditional license for a cannabis cultivation and production establishment for True Harmony Company LLC.
All those in favor? Oh, I'm sorry. Is there a second?
Member Merritt, I'll second.
All those in favor?
Aye.
Aye. All those
Aye.
opposed? All those opposed? All right, we have 4 in favor. Thank you so much.
Thank you so much. It means a lot to us.
Congratulations.
Thank you.
Thank you.
Okay.
Should we take a recess? Yeah, we can.
Let's take a 2-minute. We're going to take a 2-minute recess.
King the
Okay,
list.
guys, that was 2 minutes. Exactly. Go ahead and have a seat. Thank you.
Good job.
He was like, he's very.
Okay, thank you, everyone. Thank you for your patience. We are going to go ahead and go back to item 5, which is the petition for additional retests filed pursuant to NCCR 11.0757. And go ahead. Yeah, thank you.
Good morning, members of the board. Kara Cronkite, Chief of Health and Safety for the record. I'm here to present agenda item number 5A, which consists of one petition for additional retests of failed cannabis from Matrix Nevada LLC, hereby known as Matrix. Matrix filed this petition on September 12th, 2024, requesting an additional 50 retests after failing initial laboratory analysis. The facility has provided a list of the previous 50 retests completed and is now requesting approval for an additional 50. CCB staff review revealed that they have only utilized 44 retests, as 5 lots were requested and approved for extraction instead of additional testing, and 1 lot has received approval but has not yet been submitted to the assigned laboratory. After review of the initial petition, CCB staff requested additional information from Matrix, including any corrective actions which have been taken to address the contamination within the facility. Matrix provided a response on October 1st, 2024. You're off here. The plan for addressing the fails included additional cleaning and sanitizing of grow rooms and ventilation systems, upgrading grow room environmental monitoring, consultation with HVAC specialists, and upgrades to ventilation systems, environmental sampling of the facility, improvements to grow design, including watering and drainage systems, upgrades to eliminate standing water, increasing contamination risk mitigation through the use of foot baths for employee shoes, a change in grow medium, and increased use of hydrogen peroxide-based pesticide and remediation devices. The planned improvements by the facility represent a comprehensive plan that aims to address the issue in multiple ways. Regarding the results of the requested retests, about half passed quality assurance testing by the second laboratory. Of the 19 lots that failed retesting, 17 have been submitted and approved to be sent to extraction. The remaining 2 lots have not been requested but would be eligible for approval to be extracted. That means none of these lots are going to waste. The board has the discretion to take the following actions: grant the petition and allow all retests requested, grant in part the petition and allow some retests requested, deny with prejudice, deny without prejudice and allow the licensee to file a second petition before the end of this year, deny in part but allow licensee to request to remediate or send the failed cannabis to extraction, any other action the board deems appropriate. I'm available for any questions, and my understanding is that Chad Westham is available to address any questions you may have as well. With that, Chair Freilich, I'll turn this back to you.
Thank you. Good morning.
Good morning.
Good morning. So do you have an affirmative presentation or any questions?
Good morning. My name is David Tuttleman. I'm the managing member and founder of Matrix. Been here from the start. Mr. Westham is more qualified to answer some of the questions, but I just wanted to arrive and come and talk about the commitment of Matrix to the licensing efforts we've done, all the testing efforts. We work very hard. We have a diligent team. We've made many, many changes to the environment and to the organization to benefit the quality of our product. We are committed to continually provide high quality product to the marketplace. And as the founder and here from the start, I remain in charge of the entire operation and are committed with our team to do so.
Okay, so I understand you have 5 retests left.
Yes.
But you're asking for 50, the maximum.
Yes, please.
And what's your response with regard to the fact that there would not be any waste of the product because there would be the option of extraction?
As you know, the pure flower is a real good commodity, and we pride ourselves on quality flower. Yes, we engineered and designed our business to have a secondary use through extraction, and that's wonderful. And we have products that we provide to the marketplace that have been somewhat successful. So the use of transferring it to our production facility is part of the design. So I'm not positive of your question. And respectfully, I say we're capable of doing so, and we will manage the product accordingly with compliance. But the ability to have retesting so that we can put it out as quality flower that it really is our request.
And other than the financial piece of it, what is the downside of waiting the last few months before the beginning of the year? Because it's my understanding that at the beginning of the year, then you get another 50 retests.
Understood, and I appreciate that. We just believe that the market is demanding our product as it has since the beginning of our licensure. And we just want to be able to have a consistent flow of the product and put into the market the product that has been affected by all these positive changes. And there's a chance that we may not need them, but we just want to have that option, that business option, to be able to get this, put it out in a consistent flow.
I'll open it up to the board members for any questions, comments, concerns that you might have.
Member Durrett, I have a couple questions. Is Chad still on there? I'd like to hear from
I'm here.
Oh, I'd love to hear your thoughts in general on you and Kara and Steve actually were the ones that put this in place back forever ago. And it seems like we've really we did the right thing here, because we have not many facilities coming back to need more tests than this, but gave ourselves the flexibility if it was necessary. How do you think it's been going, and what do you think about in general the need for retests beyond 50?
Sure. Member Durrett, Chad Westham for the record. Thank you for the opportunity to comment. I think it's a good system. The fact that there's only been a few needs over the last few years speaks to the appropriateness of the regulation. As far as Matrix, the list of all the corrective actions they've done to mitigate the mold and microbial growth is long, and we're working with 374 labs to just dial in exactly any trouble areas in the grow rooms. So like David said, we'd appreciate the approval of additional retests so that we would have that option to sell it as high quality flower rather than sending it to extraction.
I guess my only other question is, why not ask for 10? I mean, I think you probably just want to ask for what you need, be done with it for the rest of the year, but I think 10 would be plenty, and I think you'd get probably more support if you asked for less than 50 retests.
We filed for 50. We thought that was kind of the lowest common denominator. That's all. It's not that we expect to use that, but it was just sort of our interpretation.
Yeah, that was my question exactly. You probably just thought that was the number to ask.
Yeah, we thought that was the denominator.
Got it. Okay, thank you.
Any additional questions? Is there any concern by the board with regard to the request to retest being used as not what it was intended for, instead of basically remediation or and I don't know if that's the correct term, but instead of doing what the corrective measures that staff has recommended, and instead of doing that or getting to the root of the problem, than to ask for retests to kind of avoid that? Is there any intent with regard to that?
With due respect, we work very, very hard, and we've made a lot of changes, and we've been incredibly involved in all these different changes. And we believe that we are, this is nothing but our ability to be, or our desire to search quality and remediate these issues. And we've made massive amounts of changes. We've even brought on a team member, a high quality guy to focus on this. I mean, this is by no means, and I know that it may appear to be something other than it is. We're fully committed for compliance and for testing and for a flow of quality product throughout our environment. And I assure you, as I have been here for the whole time, that this is nothing but above board and a straight interpretation of the denominator and just a number. And if you could allow us this, we strive for quality, but it's by no means. I mean, I want you to see it in my eyes. This is a truthful and a straight quality environment, and are welcome to come out and see the property as the staff has and the management has. And we appreciate any considerations at all times with what we do.
That would be my only concern.
Sure, I sincerely appreciate that, and I'm giving you my statement that that's not the issue. But I can understand what you think like that.
Are there any additional questions or concerns or comments from the board members? Any recommendations?
Member Drett, for my part, I'd be happy to support 10 more tests. That seems like plenty to get through the year. Do you think that's plenty?
I mean, I'm not qualified to tell you that there is. Yes, it is the middle of October. If it makes you feel better, if you'd want to reduce the number, if we have the ability to make that right now. Again, I know it renews in January. Can we say 20 at this point in time, or cut the number in half, split it in half? Either way, whatever makes it possible, we will abide by.
Thanks. I would be comfortable with 20, like I said, to get you through the year while you're while you're making changes to continue to improve. You and Chad need to work closely with Kara and make sure that you're following her guidance. And
as we do,
I would not want the production to have to stop before the end of the year. So I'd be comfortable supporting that.
Thank you.
Is that a motion?
Okay, I move to approve 20 retests for the year.
Is there a second?
Member Merritt, I'll second.
Okay, we have a first and a couple of seconds. Any discussion on the motion?
Member Douglas, for the record, I can't support 20. I think 10 would have been more than adequate to the end of the year, understanding that in January they get a new 50.
Thank you. Any additional discussion?
I would add that if you come back for more than 20, it probably won't be pretty.
This year, you will not see me here.
With that, I'll take a vote. All those in favor say aye.
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 Any opposed?
Nay, Douglas.
Okay, and motion carries. Thank you very much.
Thank you all.
Good luck to you.
Thanks so much. Thank you.
So we did item 6 on our agenda, so we'll go on to the next agenda after that, which is the consideration of licensed agreements. This is a management agreement between Paradise Wellness Center LLC doing business as Las Vegas Relief and GLP Las Vegas LLC. Do we have presentations? Good morning.
Good morning. No presentation, but I'm here for Paradise Wellness.
Okay.
Good morning. Chair Guzman-Freilich, members of the board. For the record, I'm Rachel Branner, Chief Compliance Audit Investigator for the CCB. I am here to present Agenda Item 7A, which consists of one management service agreement, or MSA, between Paradise Wellness Center and GLP Las Vegas LLC. Paradise holds combined medical and adult use cannabis dispensary license D138. The parties submitted the MSA request concurrently with a TOI request whereby Paradise will sell its dispensary license to GLP. The MSA provides for GLP to manage Paradise's day-to-day operations pending the completion of a TOI investigation. In exchange for services rendered, Paradise will pay a management fee of 70% of net revenues to GLP. CCB staff have reviewed the MSA and found the relationship between the parties appropriate. I am available for any questions, as are Amanda Connor, John Mueller, and Michael Hayford. With that, Chair, I turn this item back to you.
Thank you. Good morning.
Morning.
How are you?
Good.
Good. Any additional comments? Any changes since the information that was submitted?
No.
Amanda Connor for the record, just to make sure the record's clean, my client John Mueller is available via Zoom as CEO of GL Partners, Inc., the proposed company to come in and manage.
Great. Good morning.
John Mueller for the record here, CEO of GL Partners, Inc. One, I apologize for not being back there again. So first and foremost, I appreciate you taking up the agenda item, as we're excited to come back as I was there, 2 months ago, I guess now. But we're obviously excited to come back and do more in the Nevada market.
Great. Thank you. Appreciate that. Okay, I'll go ahead and open it up to the board members to see if there's any questions or concerns or comments with regard to this agreement. Member, for the record, so it's anticipated that GL Partners will be purchasing it?
Correct. Through its subsidiary, GL Partners will be acquiring the license through a TOI subject to board approval.
I'm going to have a lot of difficulty keeping GLP separate from GLP.
Yes, I do as well.
Okay, that's my only question. Thank you.
I don't think I have any other questions. It appears that everything, all the licenses are in order. This agreement will be in order. So any additional questions from the board members? If not, then I'm prepared to take a motion.
Member Durrett, I move to approve the proposed relationship under agenda item 7A.
Member Douglas, second.
We have a first and a second. Any discussion on the motion?
Member Douglas, for the record, the only item would be just the tail on it, that we put a 1-year check to make sure the TOI has gone forward, or the management agreement is still in place.
My client would be agreeable that if the TOI is not approved, that we come back in 1 year to discuss that.
Okay.
Member Durrett, I amend my motion to include a 1-year status check. And I hope you come out, John. I'd just like to see it be difficult for you.
Right, that's going to be a fun one. And also, after I forgot your Ely connection there, so we'd love to host you up there as well. So
check it out. Yeah.
Yeah.
Okay. That sounds good. So just one last question real quick. So is everything up and running with the dispensary?
It's up and running.
Okay. And I mean, it just was a change, right? Was there a change in names?
There's no change in names yet. The management company, subject to approval and any other local jurisdiction licensing, would then come in and manage, and potentially with either the management or TOI, there would be a name change. But right now it's fully operating and we'll stay.
Las Vegas Relief.
Yeah. Okay.
DBA Las Vegas Relief.
Okay. So yeah, everything's still the same. Okay. After this, then at some point it would change. Okay, great. With that, I'll take a vote. We have a first and a second. Any discussion? We have no discussion. All those in favor say aye.
Aye.
Aye. Any opposed? Motion carries.
Thanks, guys.
Thank you.
Thank you all, as always.
Thank you. Right, then we'll go to the request for transfers of interest. We have one under that agenda item. And who'll be doing the presentation? Okay, thank you.
Chair Guzman Freilich, members of the board, for the record, I'm Rachel Branner, Chief Compliance Audit Investigator for the CCB. I am here today to present Agenda Item 8, which consists of one request for approval of a transfer of interest or TOI application. Item A is a TOI application by Jushi Holdings, Inc. TOI application number 24000011 requests approval for Dune Operating Holdings LLC to purchase Jushi's production license P087 located in North Las Vegas. This purchase should augment Dune's existing business operating a cultivation facility also in North Las Vegas. Both Jushi and Dune have requested waivers of NCCR 5.110 pursuant to 5.112. If approved, the requirements for prior board approval of transfers of less than 5% of ownership will be waived. Both companies have adequately addressed the items required in NCCR 5.112 to allow the board to approve such waivers. Staff suggests that if approved, the board approves separate and distinct waivers and limit both to expire on each individual company's next TOI agenda date. No areas of concern were developed during this investigation. I am available for any questions, and my understanding is that Melissa Waite, John Barak, Connor Yee, and Matthew Dyson are available to address any questions you may have as well. With that, Chair Guzman Freilich, I'll turn this item back to you.
Great, thank you very much. Welcome.
Thank you.
You've got quite an organizational chart going on here. What's going on?
Good morning, Melissa Waite with the law firm of Dickinson Wright. I'm here this morning representing Jushi Holdings, Inc. We have the president, John Barrick, is also on the line today as well. With me is Connor Yee. He's with Dune, and if you'd like to give a quick introduction.
Good morning. Thank you for the time and for taking our TOR hearing. I'm actually joined by Matthew Dyson as well here, but
You could bring a chair up, yeah.
Make you guys work.
Yeah, sorry.
Just wasn't sure the procedure.
Good.
Make it up as we go along.
Don't say that. Yeah, sorry.
Just kidding. Okay.
But yeah, so we're seeking approval for our TOI for Jushi's production license to add to Dune's existing cultivation. This is just going to help us really compete in the market and move from just flower products to being able to sell to just the broader market as a whole. So we really appreciate everyone's time and efforts in getting this investigated and squared away.
Any comment from your other client?
No, I don't think we have anything affirmative to present. Thank you, Rachel and staff for, and Angela Dean is the one that pushed this along for us. If you have any other questions, we're happy to answer them. Otherwise, we would request approval of the transfer.
Any questions from the board? Any comments, concerns? Quips? That's a good sign. Okay. Then I'm prepared for a motion.
Member Douglas, for the record, motion for approval, also noting the request for the waiver of NCCR 5.110 pursuant to NCCR 5.112.
Okay, we have a motion. Is there a second?
Member Durrett, I second.
Any discussion on the motion? Hearing none, all those in favor say aye. Aye.
Aye.
Any opposed? Motion carries. Congratulations.
Thank you.
Thank you.
Thank you.
Thank you
Very much.
Thank you. Okay, moving right along. I like this. You do half and I do half. It makes things really easy. It goes by fast. Let's see, we have the items for discussion. Okay, and so we've got two items under that. I know that we've had, at least since I've been on the board, we've had a lot of discussion, or at least some concern with regard to non-response to CCB staff and agents. And we wanted to talk about what can we do about that? Because I know we have authority to take action. We just have decided not to, but I think it's not just me, but we believe it's time to take some action. We just have to decide what form that action will be in, and let's open it up for discussion and see. I know that we've got in our under our rules or under our regulations, we are able to sanction for basically non-response or for our agents not being able to do their job. And we want to find out what the board members think about what that process looks like, or I know we've talked about, we have a complaint process, which works well. We've done it with all our other disciplinary matters. I know there was some discussion with regard to an order to show cause, which is a little bit more complicated, and there's a lot of steps to it, but we also have that available to us. But we already have the complaint process. Basically, it's a well-oiled machine as far as everybody knows how that works. And I think it's been pretty successful in that a lot of our complaints get resolved. So what's on the board's mind with regard to action for non-response to CCB agents, which I was surprised that we actually deal with that just coming from other agencies, because, you know, if other agencies need a response in order to do their job, it's a no-brainer. The industry, whatever that regulated industry is very responsive. And not that everybody is non-responsive, it's just that there are those players out there who just ignore staff's calls or inquiries, and they're asking for something, but then you're not giving us the information in order to make that happen. So any thoughts?
Member Douglas, for the record, I'd like to hear from Chief Staley as to how much of a problem this is, but from my position, it's a licensee's obligation and various members who communicate with us to respond to requests from the agency. It's a waste of the agency's time to send out second and third requests. In many cases, we have situations where there's legal strife or corporate strife, and people are leaving their agency. But I would think that because they were required to have credentials to be involved with this, that they respond to what goes out, at least tell us we're no longer involved. That's the new point person, or don't ask us anymore. So in other agencies, there is a penalty. A lot of them say you can't be involved with our business for a year or 2 years when you've been non-responsive. So, Mr. Staley, do you have any problems of that?
Excuse me, Member Douglas, it's not a problem until it is. For the most part, you know, the licensees that have submitted an application to us are interested in having the application completed, and therefore they're providing the information we need. There are circumstances depending on the company. In some cases, as you mentioned, I think we saw last month an entity that was in bankruptcy protection in Canada, and all the executives had left without first providing some kind of continuity to somebody that can answer our questions. We also have, if we have a contentious TOI investigation, we have found that some applicants will stop responding to our request for information as a way to, maybe we'll get bored and move on, rather than providing the information we're looking for. It's particularly difficult because right now, and for the last couple of years, you know, the industry is struggling financially. Each of my agents is handling anywhere between 3 and 5 investigations. And when we have responsive ones, you know, they're trying to balance multiple different investigations so that we can get as many before you as possible. So when we have a company that is not responsive, the agent will, they're managing 4 or 5 different investigations. They'll routinely go back to the ones that have been non-responsive and say, hey, we're still looking for this, which interrupts their ability to continue with the ones that are responsive. I think we read into the record that True Harmony had a very quick background investigation, not because they were any less complicated than any of our other applicants, but we received information either that day or within 24 hours, which is unusual for our TOI investigations. So the problem is that when we have non-responsiveness, the agents are simply not able to do their job. And it also impedes their ability to some degree to complete the work on the other investigations they're doing.
Is there a line in place as to the cards that they have to receive to be spokespersons are involved that says we can discipline them if they do not respond or follow procedure? If you're aware.
I don't think that there is a clear path for any kind of disciplinary action against those individuals that simply just stop. And I will defer to counsel.
Sure, I think I can answer that question. I mean, this comes up in several different contexts. And I think Mr. Staley's discussing the transfer of interest context. You may have a seller and a buyer, and the buyer wants to buy it, and the seller's not being responsive, and we need information from the seller. Technically, the owners are supposed to have agent cards, which could be disciplined with, several different violations, such as obstructing an investigation is a Category 1, failure to properly and timely respond is a Category 4. But if they are going to be out of the business, what do they care? I mean, other potential solutions are to deny the transfer of interest, make them go back and get a receiver. There's the cannabis receiver, regulations as well. And you could say, look, we can't deal with the seller because they're non-responsive. Deny the transfer of interest and make them say, you got to get a receiver over this company, and then come back and we'll look at the TOI again. And then I think it would be up to the purchaser to come back and move the court for a receiver and seek the CCB's approval of a receiver. So that's one potential
solution. The intent is not to slow down the process of going forward. The intent is to make sure that the person who's doing this non-responding doesn't turn around, come back in our industry within a year and a half, and we say, welcome back, and have them blow us off again. That individual needs to be, from my standpoint, prohibited from coming back in our industry for, say, 1 or 2 years.
That I think could be accomplished
something like that
via the suitability investigation. If they do try to come back and buy another license or apply for a license, they're going to undergo suitability, the statutes and regulations. And I think that would be a factor Mr. Staley would evaluate as far as suitability. And of course, there's other contexts where we get, there's non-responses for audits and investigations, but those are referred to us for investigating the possibility of a complaint, and complaints have been filed under those contexts as well. You've seen those before. Not many, but there's been some.
So it sounds like to me that depending on the circumstance, there's different avenues.
And I think the order to show cause is another potential avenue where you would call somebody in front of you to find out what's going on. You have a right to call them in front of you. Now, discipline would, if they don't show up, then we'd have to talk about discipline separately. It could be referred to the AG's office for a potential complaint. But assuming they show up and you're satisfied with their response, then hopefully that moves things along. So the order to show cause could be used as sort of a warning mechanism. I hope that answers your questions.
It does. Question. I was just going to say, and our director would then basically be that
Conduit.
keeper, but face, right, the conduit to make those things happen, and with your council, then determine which disciplinary procedure would come before the board.
Correct.
Member Durrett, for the record, I would want to hear from the industry and attorneys before we made any decisions on this. I think one way we could get feedback, because I just want to hear what they're thinking. I mean, if there's kind of like derelict facilities that aren't responding, we're not going to hear from them, and we're not going to, so they're not going to be, it's not like we're stopping to consider their feelings. We have a good attorney bar in this area that have been doing this for 10 years, and often they have good feedback and can give us, both sides of the coin. So one way we could hear back from them is they have a annual conference coming up. That might be a good time to get some feedback on what is happening on that side of things where there could be non-responses. I would assume it's not the attorneys, it's the facilities that aren't represented, but start with the attorneys. If it's the facilities that aren't represented, then that's not really going to be very helpful. But I would not want to see us expanding our discipline efforts. I think, everyone worked out some issues related to discipline, and we're in a great direction. And I wouldn't want to see those expanded unless in extreme cases where it needs to, where they are, there's probably other things going on at that point if that weren't discipline, if it's bad enough and they're not responding. I think orders to show cause are a great solution. I think of that, we had the facility in Winnemucca that was unresponsive, and once they were brought to our attention and the board brought to their attention how serious this is, they changed course. And, maybe over time they'll fall back to what they were doing, and we can't babysit everybody, but I think orders to show cause, we have rarely used them, maybe once or twice. So I think we should seriously explore that, because that brings them to our attention. It gives them due process to share the facts on the record, and so it's not handled, because if it's handled differently by different agents, there could be inconsistencies. So the order to show cause would bring about some more consistency. And I had one more thing to add to that. I just think we should try the orders to show cause first. If I remember the other part, I'll chime in.
Well, and with the complaints, we do have that process, right? We prepare a complaint, we serve it on them, they have the opportunity to answer. And ultimately, they either settle or go before a hearing officer. So I think that's a streamlined process that we can use right away. And with the order to show cause, it's just a little bit more cumbersome in that, staff has to come to us to seek the order to show cause, and then they have to serve it on them, and they have to come back, and then we have to have a hearing, and it does tend to prolong things. But
I remember, with the complaints, that's, our version of like a criminal proceeding. I mean, it's not a criminal proceeding, but it's like very serious for these businesses. So I think to use complaints to get compliance is not the friendliest way and the most collegial way to do things. I think since there are other avenues, we shouldn't go to that length. But I wonder, especially because we have publicly traded companies, and so that could impact how they are looking and to their shareholders, which if they weren't disciplined, then they weren't disciplined. But if this is being used as a tool, then I think there are better tools that are not so serious and scary to the business. But is in gaming, would they use complaints?
They don't
in that manner.
They don't have that issue.
Yeah.
When they do, it's something really, really serious.
But they are probably, it's serious to do a disciplinary proceeding in gaming and looks really bad for the licensee.
Well, in our complaint, it's administrative, so it's not filed with the court. So there is that process that it doesn't get to that level until judicial review. So I'm talking about for publicly traded companies. But I mean, this is good. I mean, this is a discussion about what we think would be the best way to handle. And, you know, everybody in this room doesn't fall under that because they wouldn't be here. It's the people that don't even show up because they don't even answer our calls, right? So, yeah, any.
Can I ask one more question that it's a question, it's not a position. If they're requesting a transfer and not responding, the punishment is they don't get their transfer, right? Because they're taking too long to respond.
They can't complete the investigation.
Right. So it's kind of baked in.
And in that case, you would be potentially punishing a new entrant into the industry that could be a really good contributor in the way of taxes and employment and bettering the overall health of the industry as well. So
that's the buyer you're talking about?
That would be the buyer. So we would hope that the buyer is going to be able to take the assets of the seller and do better, right? I mean, they have the interest and they have the capital. Usually at that point, the seller is kind of checked out. So it would be punishment, but I think it would be directed at the wrong party.
We talk in terms of, you're talking in terms of punishment and hurting buyers and whatnot. The intent is not to hurt buyers. The intent is not to hurt entities. It's individuals who are non-responsive. This is a business. We're talking about business people. Whether they're high-scale business people or low-scale business people. There are rules. It was mentioned earlier about some due process and whatnot, and I think that if we're looking to do something like that in the non-responsiveness when requests are made, at some point, whether it's the second or third or fourth request, wherever it is, something should be sent out saying, you need to respond. If you do not respond, you may be found unsuitable as to future licenses, something like that, before we go forward. So they're aware that there's repercussions for this non-action. Because again, we have limited resources. You're making our resources waste time consistently going after these people. And the board and the agency is taking more time on items that could be done expeditiously. As you said, if they have counsel, it's normally not a problem. Probably 95% of the people in the industry respond to this. But usually it's companies that are in economic crisis, I'll say. And the people involved that don't understand, they have an obligation to let you know that they're no longer the one. That way you can zero in on the one and give us a full report. So that's what I'm talking about doing this, so that you don't have a lot of things that you stuck in the closet because you're not getting responses and slowing down.
Do we have letters of warning like that we send out?
We can't, I mean, certainly we could put something like that together. Typically, we will send, the investigation staff will send out a letter kind of laying out, look, we've tried to contact you here and here. We're unable to put the item on an agenda unless we get a response. But we could include new language that, future suitability could be impacted by their lack of response.
Because clearly we don't want to take advantage of anyone by not giving them an opportunity to respond. We're trying to get them to respond.
Even the language with regard to the regulation, is that 4.035 and 4.055 maybe?
I think so, yeah.
With regard,
That's right.
with regard to obstruction, could be put in those letters. bold, underline, so that, I mean, that's perfectly, within our authorities.
For the medical board, if an investigator wants to speak to a physician, they send a letter to your office. And if you don't respond, then they send a certified letter to your office. And then if you don't respond, you'll get your license suspended. And then you won't see patients. So it works.
Member Drett, is the issue more about individuals and their agent cards calling them forward on their agent card? It's not so much about business entities?
From my perception, the difficulty we're running into is most of our statutes and regulations speak to the license. They don't speak to the agent card. Now, the agent card is person specific, and that seems to be, so if we have an individual that represents a company that isn't responsive and the company isn't responsive, our leverage is limited. I think perhaps the risk of not being found suitable in the future, which would go to ultimately to the agent card, might have some teeth.
Okay, Member Drett, I would think if that person had been brought forward on an order to show cause and then it's later up for suitability, that order to show cause would be like a good thing to have in their record. So we know that they're somebody that we've already had to call. And is there maybe room for a regulation reform, making it clear that agents are responsible to respond to I would think they all feel that way. I think there's a sense in the industry that they're obligated. So I don't think it would be a big culture shock to do a regulation reform, making it clear that agents are beholden to be responsive.
You could still discipline an agent card under the regulations we've already mentioned for failure to respond or obstructing an investigation.
Any additional comments or questions? This is just for discussion only, so we're not going to take a vote on it, but at least staff has some direction. Okay. With that, we'll go to item B under this agenda item, and that's establishing a CCB policy for extension requests. And under that, maximum number of extensions. And I know, Member Douglas, I know this has been something that, something of a, what is it, a burr under your
It's not just a
saddle?
under mine. Member Durrett has spoken out prior to me, kind of joining her. We're probably on different levels, but we both were concerned about the extensions. Understanding we had a bunch on today. They ranged from location suitabilities in the jurisdictions because of landlords, or zoning waivers, or moratoriums in various districts. Those are understandable. But when they go and it's 2 years and 3 years down the road, they haven't even moved on anything, and they want another extension. We have a license that's not available for someone to use, and they're just holding it. And it's not a lotto to get a license so you can sell it to somebody else for more money. That's not how it should be perceived. If you get a license, you should be going forward with the business. And we understand because we give extensions. And in some cases, we see what's going on. You've had a moratorium. Finally, the moratorium is lifted because of work in the jurisdiction between that jurisdiction and licensees. Culture changes, or COVID, or other things. But when you just don't go forward at all, and you keep wanting another 12 months and another 12 months and another 12 months, or we've had a couple that got into a business And they said, we don't have the cash to go forward. And that was a requirement, so to speak, that they promised they had enough money to go forward. We should be looking at that because people who aren't in the industry are saying, we'd like to see another licensing round because we want to get involved in the business. So now we have this carrot out there. So it's problematic since we have a limited amount of licenses to make sure a licensee is going to use it for its intended purpose in a reasonable amount of time.
Any recommendations as to what we could do with those licenses that fall under that bucket that you just mentioned?
You know, remember Durrett has in the past said we should have some standards or guidelines to look at. I mean, we do have the ability just to deny a request for an extension. That's the one thing we can do clearly from what's on the books. We've tried to stay away from just doing that. We don't want to appear draconian in terms of just denying a person's right to go forward with their business opportunity. So I guess it's up to us to, if we grant an extension and we're not happy with granting it, put something on the record that clearly indicates that, hey, if you come back in another 12 months or whatever it is and you've not taken any steps, we're just going to deny your request and your license is vacated.
What's the process once, I understand that if you would give them a warning of, okay, you have, this is your third, fourth extension, yearly extension. If you don't get something underway to our satisfaction within the next year, we're going to deny your next extension. Then the year comes up and they haven't taken those steps. So then what happens when we deny an extension?
Well, they have to have the final inspection within 12 months. If they don't get an extension, recollections, the regulation says that your license is deemed voluntarily surrendered.
So then it could not be used by anyone else.
Unless there was another licensing round.
And we've never done that before, correct?
Done it for renewals, but don't think we've done it for failure to get the final inspection.
We have the statistics. I recall getting the statistics or the data as far as how many licenses are out there that are
surrendered.
Not surrendered, but that keep coming up for renewal.
Renewals.
But then there are those ones that cannot do anything because of a moratorium or because of the local entity has zoning issues. I would imagine under the scenarios of the only two they're basically, they can't do anything about. The rest is all financial or lawsuits and problems with partners and things like that. But it's under 70, right?
Yeah.
68 or
Chief Gilbert, do you have access to that handy?
To the statistics?
Yeah, just the overall number.
Yeah, the overall number of current licenses that are in the conditional status is 64. And of that 64, to your point, Chair, 11 of those licenses are in a moratorium related issue, whether it's in the county or the local jurisdiction. And then also 12 of the 64 are dealing with local jurisdiction requirements. So in that case, they're trying to meet the requirements of the local jurisdiction, which is the reason for their request for an extension. And just to give a little more insight, the extension process request process started in 2020, and then we gave them a blanket extension of a year, I believe, around that point. And at that point, we had 145 licenses that were granted an extension representing 66 entities. And put it into perspective, currently, we're dealing with the 64 licenses and 43 entities. So progress has been made, but those 64 still do remain with various extenuating circumstances that they're presenting to the board.
Thank you. And that was and that's in 4 years. And it went from what to 64, 120?
145, I believe.
Oh, 145.
Yes. In 2020, there was 145 licenses, and currently there's 64. And I would like to note that of that 64, 19 of those licenses are consumption lounges that just recently, within the last year or so, received their conditional license. So technically, it's 64 minus 19 of the ones that have been trying for years now. And the ones that you've seen today, there are potentially, you saw on the agenda item today, ones that have requested their 4th extension request. So some of them are up to the 4th request.
Okay, thank you. Any additional questions from staff?
Member Drett, I don't have questions, I've kind of evolved on this issue a little in that it's going to be so tough, and I just don't know where we will find a line. It's because we did proceed to issue extensions to those that didn't really have, outside circumstances. They just didn't have the money, or it wasn't a good investment for them at the time to proceed. Since we granted them, I don't know how we can now say we won't grant for that reason. It's just going to be really tough. And then between these licenses and the social equity ones, we would have to take the social equity component into consideration, and it's just going to get really difficult. So staff had advised with the difficulty of finding that line, and I agree, because I've thought about it a lot, and good luck to us.
Member Douglas, for the record, we're not looking to do something again without kind of a notice and opportunity to be heard. For those folks that we've granted extensions, they come up for another extension if they ask for it. I think we're kind of bound to give it to them, but we should give it to them with notice that when you come back in another 12 months, or hopefully you won't come back, you show us your progress report that you've gotten financing or you've made best efforts, and show us what you've done. If you've come back and you're just coming in and saying, oh, poor me, and we've told you you need to show us action or you're going forward, that we don't give them another extension, then their license is just gone. So it's not that we have to take action. I think there needs to be a caveat of a warning. The ones on today were good stewards, so to speak, even though they were asking for extensions. They had zoning issues, they had moratorium issues, they had supply issues, but they were all showing due diligence going forward. And some didn't really need a 12-month extension. They, in essence, say, hey, we only need 6 months, but for calendaring, it makes life easy to give them the 12 months. But in other cases, we've had people, they've just come forward or made the request and there's nothing. Or, as I said, the proverbial sin, gee, I don't have the money. And they made a representation when they got their license that they could satisfy the financial requirement. So whatever's transpired, whether it was much greater than they thought, is not our problem. And again, we have other people who would like to get in the business, and we're denying them. And someone has this golden ticket. They haven't even bothered. In some cases, I know with the equity, they can't put it up for sale. But In other cases, they can put it up for sale and put it in play.
I have one more question. Member Durrett, for the record, so there are dispensaries that have not opened that are not subject to moratorium? Steve?
Yes, that's correct.
Okay, because those ones certainly, those are limited. So I think those are more along the lines of you're sitting on a license that somebody else would go to somebody else.
Currently, there's 14 dispensaries in rural counties. 14 of the 25 are in rural counties. So that's 11 dispensaries that are in Clark County, in the local jurisdictions within Clark County, and Washoe County and Carson.
But some of those could be ones where they just recently lifted a moratorium.
Yes, I think, Henderson falls in maybe that category because they recently, within the last couple of years, lifted their moratorium. Sparks just recently, we believe, lifted their moratorium by the way of the SB 277 passage. And then Carson City just recently did within the last couple of years also.
Any additional questions or concerns, recommendations?
Recommendation, Member Douglas, I think we need to make it clear when extensions are granted, under what circumstances they potentially would be non-renewed. So they're put on notice. And the board can hear whatever they hear when they come back, if they come back.
Okay. That, we'll move on to our next item, which is the briefing from the chair and executive director. From me, just wanted to mention a good job on the market study. I hope everybody's had a chance to read that. That was a really interesting read, so I appreciate that. It's timely for legislative session, so thank you. And on to you.
Excellent. Thank you, Chair. Not much for me today. Just again, thank you to the staff. Thank you to the board as well. Just for all the work that's put in. And I know they left, but a thank you to True Harmony for being so responsive to Chief Staley and his team. Again, we had the discussion item about the challenges, but then when it works out like that, we're able to get them on relatively or pretty quickly once we have everything responsiveness. So we'll take everything under consideration from the board's discussion today. And then hopefully in the next couple board meetings, we'll have something a little concrete to bring in front of the board. And then also in the next meeting or so, you had asked for the legislative policy in regards to the board members. So we will take a look at that and work with the board members to bring something forward. So that's all I have. And again, thank you to the team as always. Just an incredible amount of work goes into these meetings every month. So appreciate it. And again, thank you to the board. So that's all I have, Chair.
Anything from the board members before we, I don't know, one last thing is next meeting date is November 21st. Any additional comments before we take it to our last public comment period? Okay, public comment in the south, and then we'll go to the north and we'll go online. Hi.
Shanna Perry again for the record. I was here earlier, Cannabis. What you guys were just talking about at the extension. So the paper that I gave you that I intend to lobby next year with the legislature to have some of these bills done. I'm actually working on something federally as well. A lot of this transfers, but the micro business licensing. I think that there's going to be a serious problem with the lounge licensing and the allocation to the minority community and for equity, because this is still not an equitable industry as it sits. So creating micro licenses to allow for businesses such as somebody already having a catering company and they want to add some edibles and use that to get some more businesses. Cannabis is an ingredient. this is a recreational tool. We no longer have medical and we don't do environmental, which is hemp. The reason why that other group came up and said that the hemp industry is just, they're not producing, is because the CBD is completely a counterfeit industry. I've been trying to fight against it since 2018, trying to tell people about the counterfeit COAs and all of that was happening. That was transpiring a lot, still has been, and now we're here. So there's been no protection against that. Hopefully in the federal bill that I'm working on, we're going to be separating medical, recreational, and environmental, and doing things that have not been brought to the federal government yet. So I would like to try to do some of this stuff specific for Nevada. And again, the document there with the taxation as it exists, because federal is going to have to put their own tax on it. So I think there's a lot of things that need to be worked on, and I'm here and I will get my lobby license next month. And if anybody wants to support this or join me, please do. Jana, thank you guys.
Thank you. Additional public comment in the South? Okay, we'll go to the North. Is there any public comment in the North?
There's no comment in the North, Chair.
Thank you. And what about online?
If you wish to provide public comment, dial *9 to raise your hand if joining by phone, or click the raise hand icon if joining via Zoom. There's no comment online.
Thank you. With that, we adjourn our October meeting and we'll see you next month. Thank you. Thank you for your patience, everyone.